Hi everyone, this is Professor Herman, and this week in the strategies class, we're going to be talking about multiple choice questions, and specifically using analytical skills to answer multiple choice questions. This presentation will discuss why multiple choice? Why do we use multiple choice questions in law school? And what are your professors trying to assess with these questions? We'll then dissect the multiple choice questions and look at their different parts. We'll then develop a process for answering multiple choice questions. And finally, we'll look at some examples. We use multiple choice questions in law school to test a variety of skills. The first sort of set of skills are recall skills. Can you recall the cases, what happened in the cases, the holdings, and the rules? This is probably less common in assessment in law school than the second sort of skills we test, which are analytical skills. Skills like issue spotting, using the correct rules, analysis. So we can test using multiple choice questions a lot of the same skills that we can test using essay questions. The benefit of using multiple choice questions is that we can test over a wider breadth of topics than we can test usually via essay. So you'll see that it really allows your professors to test all of the topics that you studied during the semester. So when we talk about multiple choice questions, there's really a variation of types of questions that we could be talking about. A few are K-type questions. These are multiple choice questions. So you might have a question saying, for example, the following statements are true. And then you'll have four statements and the answer choices are A and B, A, B, and C, so on and so forth. We don't use these a lot. They're not used on the bar exam. They tend to be extremely difficult. Another type is true false, which is really a sort of multiple choice question. There's multi-question fact patterns. We do see these quite a bit in law school. So this will give you one fact pattern with a series of questions to answer about those fact patterns. We, again, do see these in law school. However, they are not on the bar exam. The last type is the type I like to call the analytical or bar type questions. Called this because we tend to find them on the bar. These are what bar exam questions look like. They are analytical. They are typical IRAC type problems. And this last sort of variation, these analytical or bar type questions, are the questions we're going to be talking about today. So there are three parts of these analytical or bar type multiple choice questions. I think it's important to point these out because I'll be referring to these parts of the question throughout this video. So the first part is the fact pattern, which is sometimes called in testing parlance the root. The call of the question, sometimes referred to as the stem, and the answer choices, which are sometimes referred to as the options. I tend to call them the fact pattern, the call of the question, and the answer choices simply because I think these are more descriptive terms, something that we might call them every day. So this is just a sample question showing you the parts of the question. What the question actually says isn't the important part here. What is the important part are the labels, what we're calling it. So the fact pattern is just that, the hypothetical fact pattern, what happened in this situation, the story. The call of the question is always going to be the last statement or two prior to the answer choices, asking you something specific about this question. Here it is, if Nancy brings an action against the agency that employed Marissa on a respondeat superior theory, Will she likely prevail? So the call of the question, of course, is important. That is how you know what you have to answer. The answer choices are just that. What are your options? What are your options for answering this question? Typically, we see four. This is how they're written on the bar exam. 4 questions, lettered A through D, written in parallel format. So 2 answer choices will be no, 2 will be yes, and they'll be followed by some reasoning. It's not always yes and no. It may be Nancy, Marissa, Marissa, or perhaps you might see something that says guilty, not guilty, constitutional, unconstitutional, but they're generally written in a parallel format. That is not always true, but it is ideal. So now that we've identified the parts of the question, we can talk about our approach to multiple choice questions. When you sit down to take a multiple choice test, you want to approach it methodically. And this is a suggested approach. You might find something that works better for you, but if you've struggled with multiple choice in the past, I really highly suggest that you look at your approach so that it makes it more efficient and effective. So the approach I suggest is first read the call of the question. Read that last statement or two prior to the answer choices. Why? This is going to focus your reading of the fact pattern. Next, read the fact pattern, the story. You then need to identify the issue that is presented by the facts. What is going on here? Why is this a problem under the law? Articulate the rule of law. In your head, of course, you're not going to say it out loud during a test, although I suppose if you are taking this remotely, you can. You don't necessarily need to write it down. You might want to write elements on a piece of paper, but you need a rule of law. You cannot solve these questions without the rule of law. Apply the rule of facts to the question using the full analysis formula that we've talked about the past couple of weeks. Then determine the answer, and only then read the answer choices to determine which best addresses the answer you articulated. I think this last step is really important, and it makes a big difference in analytical or bar type questions. Oftentimes, students will say to me, I can narrow it down to 2, but then I have a hard time deciding. Or often they will think that they all seem right. They are written this way. We write them this way because we're testing particular things with these answer choices. So chances are they're all going to look pretty good. What you need to do is determine the answer first, so that way you're not swayed by the answer choices. Of all the things you can take from this lecture, I think that that's the most important thing. So let's take a closer look at this approach, specifically steps 3 through 6. 3 is identify the issue presented by the facts. 4 is to articulate the rule of law. 5 is to apply the rule to the facts of the question. And 6 is to determine the answer, or conclude. So what is this? This is nothing but IRAC. These questions are mini essays. They are testing the same skills that your essay questions are testing. It's important to work through them methodically and analytically, just like you would an essay question. So let's take a look at an example to see how we apply our approach to one of these analytical type multiple choice questions. The first step is to read the call of the question. The call of the question here says, if the fisherman asserts a claim against the movie studio for false imprisonment, which of the following would be the movie studio's most effective argument in the defense? So this is a good call of the question. This gives us a lot of information. First off, we know it's a false imprisonment claim. The fisherman is going to claim that he was falsely imprisoned. Also, we know that we're looking for the movie studio's best argument in defense of the fisherman's claim. So this tells us a couple of things. First, it doesn't really matter whether the fisherman has an airtight claim. What we're looking for is not whether the fisherman wins or loses. We don't care about that. What we do care about is the most effective argument in the defense. So already when we're reading this call of the question, we want to be thinking about the elements of false imprisonment and what might be arguable or not present at all. So having read the call of the question, we now get to move on to the fact pattern, which we can be pretty focused in reading. So in this fact pattern, a movie studio was filming part of a motion picture at a large residential apartment building with the permission of the building owner. To avoid interference by curious onlookers, the movie studio's security agents set up a command post in the lobby of the building. No persons were allowed to enter the building without identifying themselves and explaining their reasons for being there. A fisherman who lived in an apartment in the building was returning from a fishing trip late one night. Unaware of the movie studio's activities, he was stopped by the movie studio employees as he attempted to enter. Because he was not carrying identification, the fisherman was unable to establish his identity. For this reason, the employees refused to allow him to enter. After trying unsuccessfully to convince them that he lived there, the fisherman stayed with his sister who lived a block away. The following morning, he contacted the building owner, who spoke to the movie studio officials and arranged to have them allow the fisherman to enter the building. Okay, so we have to identify the issue presented by the facts here, and we might not have a very narrow issue. Obviously, the issue that needs to be determined is, can the fisherman establish this false imprisonment claim? And more specifically, what is the weakest part of his claim? Why do we need to know the weakest part of his claim? Because that is going to be the movie studio's most effective argument. So having read this and knowing a little bit, well, knowing about false imprisonment law, there's some facts here that look kind of strange. Here we know that the fisherman was unable to establish his identity and they refused to allow him to enter. Well, that seems kind of strange for false imprisonment. What we usually look for in false imprisonment is a person being kept somewhere. Okay, so we've identified this issue of what is the fisherman's weakest part of his claim. The next step is to articulate the rule of law. The rule of law we're using here, again, comes from the cases we read in the initial writing assessment. So we know from there that false imprisonment requires that a plaintiff show four things. One, that the defendant intended to confine her. Two, that the plaintiff was conscious of the confinement. Three, that the plaintiff did not consent, and four, that the confinement was not otherwise imprisonment or was not otherwise privileged. We also know that a false imprisonment claim requires a prima facie showing of actual confinement or threatening conduct. So we want to use these rules in order to determine whether the fisherman has a claim for false imprisonment, and more specifically, what is the weak element he has. So we're going to use our full analysis as usual. Are you going to draw this box out every time you're answering a multiple choice question? No. The point is here that you really just want to be aware that the process is the same. So we need to look for all of these elements in the multiple choice question. Why? That's what the fisherman has to prove. So the first is confinement. We know that the fisherman was not allowed into his apartment building and he had to stay with his sister. So he was kept out of a place and not in a place. So we don't have this element. This is a multiple choice question. We're not writing an IRAC, so we can stop here. We know the fisherman was not confined. So our next step is to determine the answer, which is that the movie production company is, its best defense is they didn't confine the fisherman, right? They didn't confine the fisherman at all. They kept him out of the place. They didn't keep him in a place. So our next step and our last step is to read the answer choices and determine which best addresses the answer you articulated. In evaluating the answer choices, we want to think about three things. First, does the answer choice properly reflect the facts? Two, is the reasoning legally correct? That is it applying the law to the facts correctly? And three, is it the best answer choice? Is it the best one of all the answer choices? So there's a few ways reasoning can mischaracterize the facts. First, it can be a blatant contradiction of the facts as stated. You're probably not going to see this much at all. This is too obviously an incorrect answer for it to be placed on your exam. However, it does test reading comprehension, and every now and then you might see an answer choice that just blatantly contradicts the facts as stated. The second thing that can happen is that the answer choice goes beyond the facts, and you're more likely to see something like this. The answer choice could be right if certain facts were present, but we don't know that these facts are present. The answer choices, or rather the hypo doesn't speak to them. You're just assuming facts. The answer choice goes beyond those facts in the hypo, and therefore it's probably not your best answer. The answer choice can also assume facts in dispute. It might not go beyond the facts. The hypothetical might actually speak to those facts, but the factual situation hasn't been resolved. So if the answer choice assumes that those facts have been resolved, it's probably incorrect. The second way answer choices can be wrong is that the reasoning is legally wrong. There's something wrong with the rule or the analysis. And this is most likely what is wrong with the answer choices. This is how we get our true distractors, the distractor, the question, the answer that looks right, but it isn't right. So this can be done in a variety of ways. The reasoning could use antiquated rules or rules from inapplicable bodies of law. This happens a lot, not always with antiquated rules, but often with inapplicable bodies of law. So we might see UCC, Uniform Commercial Code, versus common law. So you have to know whether you're working with services or goods. We might see the Model Penal Code versus common law. We might see a majority versus a minority rule. So as opposed to using something from a completely different class, you're likely to see something like a jurisdictional split or a rule that isn't used in a particular situation. The reasoning could also apply a rule that just isn't applicable to the facts. You're just using the wrong rule altogether. This is an issue spotting problem. The answer choices could make an over-inclusive statement of law. So watch out for words like always, all, anything that gives a definite statement that something is true in all situations. It's not usually the case in law. We oftentimes have situations that vary or have exceptions. So be careful about words like all or always. The answer choice could overstate or understate the applicable legal standard. This is kind of similar to 3, except we're talking about the actual rule here. Is the rule kind of adding a requirement or ignoring a requirement? So in that situation, the reasoning is going to be legally wrong as well. Finally, an answer choice could be incorrect if it is not the most precise or effective answer choice. Sometimes there'll be more than one right answer choice. And I know this drives law students insane, but it is pretty common. So you need to be able to choose the best answer choice. So it's not the most precise or effective choice in a couple of situations. One, an answer choice that is easier to prove is more likely to be correct than an answer choice that is difficult to prove. For example, intent or causation is usually harder to prove than damages. An element or other rule component is easier to show than an entire rule. So if you have an answer choice that speaks to showing intent, to showing causation, it's probably not the best answer choice if another answer choice speaks towards damages. Secondly, a more precise answer is better than a less precise answer. Usually the answer choice with more correct information is more likely to be correct. A couple additional suggestions and evaluate answer choices. First off, watch for the words if and because. It's very common to see them introducing a second clause in an answer choice. Obviously, they mean very different things. If is going to give you a set of facts, a fact that you're going to assume is true, right? If that fact is true, then is the answer true? Because, of course, means something different. Because has to be true on the facts, right? Because is going to support the answer in the prior clause. Look for answer choices that state the rule, that state elements of the rule. This is likely to be a good answer choice. If the answer choice is stated in terms of the rule, it's likely to be correct if the facts are correct. And again, be careful of absolutes. Always, never, all, none. Why? Oftentimes we just don't have absolutes in law. There's usually a situation, all it has to be is one, where this isn't true. So be careful of absolutes. So back to our example. We're on to our last step where we're going to read the answer choices and determine which one best addresses the answer you articulated. So take just a moment to review this question before we move on to the reasoning and answer choices. Again, this is our application where we decided that there was no false imprisonment because the plaintiff was not confined. So now we're going to look at our answer choices and determine which one best addresses the answer choice we articulated, which is that the fisherman was not confined. So A says the movie studio employees did not know that the fisherman was entitled to enter the building. Well, that doesn't really speak to confinement, so that's probably not going to be our answer. The conduct of the movie studio employee was not unreasonable. Again, doesn't speak to confinement, probably not great. Then we see C, the fisherman was not imprisoned, and think, yeah, that speaks to confinement. Imprisonment, confinement, it is probably C. Then we look at D, the fisherman sustained no damage as a result of the conduct of the movie studio employees. Well, also doesn't speak to confinement. So here we're going to choose C. Note that A is incorrect. This somehow seems to speak to intent or knowledge of the studio employees. Here, the plaintiff wasn't confined, so the defendant's intent doesn't even matter. But be careful about what intent is required here. It's the intent to confine, not to violate the rights of the plaintiff. If the defendant had knowingly confined the plaintiff, that's enough. So this seems to be adding an additional element to the rule. It overstates the applicable legal standard. B is also incorrect. There's no unreasonable requirement to show false imprisonment. This is just adding another element to the rule for some reason. D goes beyond the facts. We don't know. We don't know if the fisherman can sustain damage, can show he sustained damages. So again, this speaks to facts that are not in the hypothetical, but even so, it's adding an element of damages here that isn't required by the rule. So C here is definitely the most correct answer, and we will choose C and be correct. So let's take a look at a second example here. Again, going through our approach, we first read the call of the question, which here says, if the student institutes an action for false imprisonment against the professor, who will win? Okay, so here again, we know this is a false imprisonment question, which isn't a surprise because we know that's what we're working with. But if you were taking a torts exam, you would know you were working with the tort of false imprisonment. Here we're just asked who's going to win. It's student versus professor. I would expect to see a variety of answers of who's going to win with a because followed by it to see to show the reasoning. So here, now we move on to reading the fact pattern, which tells us a professor was disturbed by the fact that students frequently left the room during her lectures, so she instructed her teaching assistant to lock the door of her classroom from the outside 10 minutes after the class began and not to unlock it again until 10 minutes before the class was scheduled to end. On Thursday, a student attended the professor's 4 o'clock class. By 5 minutes past 4, the student was sound asleep in his seat. At 4:10, the teaching assistant locked the classroom door as instructed by the professor, unlocking it at 4:50. When the class ended at 5, the student who had slept through the class was awakened by a classmate and left the room. The classroom had been painted the previous day with a paint to which the student was allergic, although neither the professor, the teaching assistant, nor the student knew about it. As a result of his exposure to the paint in the room, the student developed allergic symptoms later that day that required hospitalization. So we've read the fact pattern. We have to identify the issue presented by the facts. Again, it might not be that precise, but we're reading this and we really want to know if all of the elements of false imprisonment are met here. So what we do next, of course, is articulate the rule of law so we can determine if that is true. Again, our rules of law that we got from our cases in the initial writing assessment are that false imprisonment requires that a plaintiff show that defendant intended to confine her, the plaintiff was conscious of the confinement, 3, the plaintiff did not consent, and finally, the confinement was not otherwise privileged. And we know that a false imprisonment claim requires a prima facie showing of actual confinement or threatening conduct. So now we need to apply the rule to the facts of the question. We're not going to draw out the full analysis box this time. However, we can still do a full analysis kind of in our head, which is probably how you're going to answer multiple choice questions on a test. So we need to know that the defendant intended to confine the student. So did the professor intend to confine the student? Well, I would think so, right? Yeah, she didn't want students leaving the class. She had the teaching assistant lock the door. She intended to keep the students there and actually confine them as, was required by our second rule here. So one is met, one is likely met. 2, the plaintiff was conscious of the confinement. Was the plaintiff conscious of the confinement? I mean, the plaintiff was literally not conscious. The plaintiff was asleep. So probably not. The student's probably going to lose on number 2. The plaintiff didn't consent. The plaintiff didn't consent here. There's nothing showing that the plaintiff consented, and the confinement was not otherwise privileged. We don't have any facts that would speak to whether a professor is somehow privileged in this situation to lock students in the classroom, but I would think and hope that that would not be true. So just looking at this rule and applying it to our facts, I am going to determine the answer, which is our next step, that the professor's going to win here because the student was not conscious of the confinement. Why? The student was sleeping. So our final step is to read the answer choices and determine which one best addresses the answer we articulated. So reading these answer choices, A says the student, because his illness resulted from the professor's intentional confinement of him. Say no for a couple of reasons. First off, I determined in the previous slide that the professor is going to win. So these student ones, I'm probably just going to cross off because I know the professor is going to win. The student, B tells us the student, since a professor owes her student a duty to refrain from exposing them to unreasonable risks of foreseeable harm. Well, that doesn't sound like the conclusion I came to. C gets closer because it says the professor, since she did not know with substantial certainty that harm would result from locking the door. Again, not the reasoning I came to in my application. And then D tells us the professor, since the student was asleep while the doors were locked. Well, yeah, that sounds right. We had said that the professor would win because the student wasn't conscious of the confinement. And the reason the student wasn't conscious of the confinement is because she was asleep while the doors were locked. So D sounds correct, and D is in fact correct. We know it's correct because we came to this conclusion in doing our full analysis. We know A is actually incorrect. A and B are incorrect because they tell us the student will win. And we know that that is not correct. The reasoning is also incorrect, which of course gives us the incorrect answer. So A is incorrect because it uses some sort of incorrect rule that requires this illness resulting from the intentional confinement of the student. Doesn't really speak to the rule that we have at all. B, the student, since a professor owes her students a duty to refrain from exposing them to unreasonable risks of foreseeable harm. This is probably true. Risk probably is unforeseeable here. but it's just an incorrect standard of law. It seems to be speaking to some negligence standard, which isn't what we're looking for here. C, the professor, since she did not know with substantial certainty that harm would result from locking the door. Again, this isn't the correct law. It speaks to harm. This isn't required. What is required is that the student be conscious of the confinement. We don't have that here. The answer has to be D, and the answer is D. So important things to take from this presentation on multiple choice is that you need to work through these questions in a methodical and analytical way to come to the correct result before looking at your answer choices. This will help you immensely in not being swayed by something that seems correct, but is in fact incorrect.